Welcome back to Canadian Justice, where we're talking about a new amendment to the Competition Act that prohibits so-called greenwashing and creates a reverse onus on businesses making environmental claims and requires these businesses to demonstrate that their claims are supported by, quote, internationally supported methodology. Now, Grant, this this new law creates sort of a specter of liability above a lot of businesses, existing businesses as well as innovative clean tech businesses. First, what are the penalties associated with breaching this law? And then I guess second, how are businesses responding to this specter of liability?
Sure. Yeah. So for this conduct, if the tribunal makes a finding that the uh, claimant has engaged in reviewable conduct, it's an administrative monetary penalty that can be assessed against the claimant for the greater of 10 million for the first order, $15 million for a subsequent order, and 3% of the corporation's annual worldwide gross revenues. So these are substantial penalties. You do not want to be on the wrong side of this provision. And that goes to why businesses in the wake of this have rapidly removed many of their representations, their information from public websites and from other sources of claims. There's been a widespread chilling effect of what information the range of companies are providing to the market as a consequence. And I think that goes to the central freedom of expression concerns. Now, the Competition Bureau, is undertaking consultations with comments due in September for how this provision is to be enforced. They put out some broad commentary about what they see as in scope for greenwashing conduct, largely in sync with how the previous provisions were applied. There is, though, the challenge that these provisions are open a year hence, but will be open as of June 2025 for private rights of action, for third parties to challenge this conduct, irrespective of whether the Competition Bureau would challenge the conduct.
And by private rights of action, you mean like a consumer might see an advertisement and say, "Hey, I think this is greenwashing," and then they can on their own bring the complaint?
Yeah, or a public interest group. And there is a gatekeeping function of the tribunal that they have to find that the action or the application would be in the public interest. But I think companies would rightly be concerned about litigation around an uncertain, vague, and again, overbroad provision.
Yeah, I mean, I've certainly seen commentary from a number of law firms in Ontario and nationally, actually, with sort of broad advice about this liability related to this new legislation. Now, we've talked about how businesses have sort of had experienced this chilling effect where they're putting either caveats on any environmental claims or completely removing environmental claims from their publications or advertising completely. Do you think that there's a risk that businesses, in addition to not wanting to talk about their environmental initiatives, they might actually just stop having environmental initiatives because if they're unable to talk about it, sort of for some of these businesses, that might be the reason they were doing them. Do you think that that is a risk here?
I mean, it is a risk. I mean, I do think, competition around environmental performance has valuably become an axis on which companies compete. It is important, again, that those statements that are put into the market not be so uncertain as to not have been backed up by some adequate and proper test, for example. But the issue here is that you may be on the wrong side of some nebulously defined, internationally recognized methodology. And one could certainly conjecture that at some margin, companies begin to limit what they do. I think, again, though, the greater concern is that the public and critical participants in the market, workers, investors, collaborators, do not become aware of what companies are doing. Again, coming back to my own motivation in writing this, I often go to public representations that different players have made for line of sight on what they're doing that may reduce greenhouse gas emissions. And having that wide availability of information motivated by perhaps commercial considerations, but put out to the public for essential understanding of where we're going on environmental performance. That is critical. That is
Right.
what past case law has centrally protected in the freedom of expression.
We've got to go to break now, but we'll be right back.